Welcome to the number 23 of the webinars of the Japan Technology Transfer Help Desk on patents, employee inventions, overview of legal systems and recent trends. Maybe I can skip the first slide that probably you know by heart if you're one of the followers. Let me introduce us super quickly to our speakers today. Dr. Berner from Murgatroyd in Munich and Dr. Fuji-san from Sonoda Kobayashi in Tokyo. The first speaker studied general physics, Technical University of Munich, completed his PhD studies Université Libre de Bruxelles in Brussels with the research of chemical reactions on metal surfaces under high vacuum, and is fluent in German, English, and French. In 2001, he started his career as a trainee at German European patent attorney in a mid-sized Munich-based German patent firm, which he completed in 2005 by passing the German and European qualification examinations. He then joined Murgatroyd in 2011 to build up and lead the German office and was appointed Director, Patents and Trademarks in 2013. In addition to this experience in patent prosecution and litigation on various technical fields, Robert also has a wide experience in matters relating to trademarks. He regularly travels to Japan to enhance the cooperation with local clients and partners by presenting seminars about European and German patent and trademark practice. As far as Fuji-san is concerned, Dr. Fuji's academic career includes studies in theoretical physics, numerical computation physics as a researcher. After receiving a PhD from the University of Tokyo, he did his postdoctoral research at the High Energy Accelerator Research Organization in Japan, worked as a researcher at the University of Bonn and the University of Cologne in Germany. He also developed the system software for information systems, and his expertise covers a vast area of physics, including quantum mechanics, plasma physics, electromagnetics, and information processing technologies. He joined the firm in 2010 and became a Japanese patent and trademark attorney in 2013. And then he became a partner of Sonoda & Kobayashi in 2015, heading the electronics, machinery, software department, as well as the trademark and design department. Without further ado, we're already very, very late. I would like to introduce the first speaker. Welcome.
Okay, thank you for asking us to make a presentation. So the title of this talk is Employee Inventions in Japan. My name is Akira Fuji, a Japanese patent attorney by Sonoda and Kobayashi. We've worked for many clients outside Japan to obtain or utilize patent rights in Japan. We have also helped their training of the workers about inventions, patents, and so forth. So, yes, here is the agenda. I have divided my presentation into 3 parts. I begin by an introduction, including a famous Japanese case, a blue LED case. I will be describing principles of Japanese patent law regarding employee inventions. I will go on to explain recent amendments made in 2016. I will end with a word on our practical advice for companies performing research and development in Japan. So here is a blue light emitting diode patent. So this patent includes a method invention which may be used for manufacturing a blue LED. The assignee is Nichiya Chemical, and the inventor is Professor Nakamura, who won a Nobel Prize in 2014. So this picture shows the very abstract of this patent. So this slide shows the history of this case. So the filing date of this patent application was 1990. More than 28 years ago. And 1997, so this application was granted. And that 2001, Nakamura sued Nichiya at Tokyo District Court. Nakamura claims that the ownership of the invention belongs to Nakamura, not to Nichiya. And he also claims that even if not, the considerable remuneration must be paid in 2004, Tokyo District Court made decision. The decision included the ownership belongs to Nichiya, not to Nakamura, and Nichiya must pay 20 billion Japanese yen. That is about 200 million US dollar, because this compensation is very huge, and this surprised us Japanese people a lot. And Nakamura and Nichiya continued that lawsuit, and 2005 settlement at Tokyo High Court was made. And that settlement included Nichiya will pay 600 million Japanese yen. We will return to this case later. So let me start with what is an employee invention. Here is a definition. So first, an employee invention is defined as in relationship with a company's business. So, and second part, the relationship with inventor's work is defined. So, and some additional definition may be necessary. For example, who is the employee or who is the employer? Here, employees includes company employees, of course, and directors, university professors, government officials, temporary staff, and staff on loan or something. So these are principles of Japanese patent law. So first 2 points are about ownership. An employee invention is initially owned by the employee inventor. But an agreement between employee and employer can be made so the employer succeeds the right to a patent for the invention. Second point is about the company's freedom to use an employee invention. Even if there is no agreement, the employer is automatically provided with a statutory lawyer-free non-exclusive license. And finally, the third point is about remuneration. If an employee invention is assigned to the employee has the right to remuneration with due consideration. But the fourth point was updated. Okay. So I'd like to talk about the background to the amendment regarding how an employee invention is succeeded. There have been 2 problems conventionally. One is here, a double assignment problem. So please look at the figures at the bottom. Here is company X, and Mr. A works in company X. And Mr. A invented some invention. So according to the company rule, that invention is succeeded to the company X. But Mr. A also assigned company Y about this invention. And company X filed a patent application on 10th of February, but company Y filed earlier than that on 10th of January. According to the Japanese patent law, the company X application is rejected by referring to the prior application by company Y. So this is called a double assignment problem. Next, please. And here is the second problem, complication of joint ownership. So company X and company Y are in joint research. Employee A of X and employee B of Y are called inventors. So they invented one invention in a corporation. So if company X wants to file a patent application, of course, company X must succeed right to a patent from employee A and employee B. But even if company X is about to succeed right to a patent from employee A, company X needs a consent also from employee B. So therefore, the joint ownership is very complicated structure. Okay. So here is updated current principles of Japanese patent law. So first feature is additional regulation. The right to a patent for an employee invention initially belongs to an employer if specified by their employment contract, rules, or the like. And the second is update or override of existing article. If right to a patent for an employee invention is obtained by the employee has a right to remuneration with economic benefit, such as monetary compensation. The third one is a new statement. The Ministry of Economy, Trade, and Industry published a guideline. Okay. So I go on to explain Japanese patent law on employee inventions enforced of April 1st, 2016. So as we have seen, employee inventions can belong to employer from the time the invention is made, if so specified. And in the absence of this agreement, an employee invention belongs to the inventor, and the employee is provided with a royalty-free, non-exclusive license, same as before. I'd like to go back to the previous examples. So before, conventionally, Mr. A can assign company Y, although according to the company rule, the right to patent was succeeded company X. But according to the new regulation, Mr. A is not entitled to assign company Y. That's why, therefore, this double assignment problem will be solved. And regarding this joint ownership problem, because company X can obtain the right to a patent, so initially, therefore, the company X is not obliged to succeed a right to a patent from employee A or employee B. Therefore, in the joint research, company X can exchange the right to a patent only with company Y. Like this, this change solves existing two problems. So, regarding change 2, the second change, this defines what is remuneration. So before adequate remuneration, before the Japanese patent law defined adequate remuneration, but the updated version defines reasonable monetary or other economic benefits. So for example, chances to study abroad, stock options, promotions, paid holidays, licenses, and other non-monetary benefits can be accepted. But of course, honorable benefits cannot be accepted. For example, testimonial cannot be accepted as economic benefit. And the fourth one, third change is about guidelines. I will explain in the next slide in the detail. So the following the guidelines define that the following 3 steps will give reasonability toward enumeration. So according to the guidelines, the following should be conducted in a reasonable manner. So here is an employee invention. So here, employee invention is done here. Before that, the company will define the standards for the remuneration, and the company will disclose the standards to the employees. And after the invention, the company or employer must hear opinion from the inventor. So these 3 steps are important to keep the remuneration reasonable. So I prepared some slides to discuss discussions or disclosure and opinion hearing here, but I'd like to skip in my talk here. So here the guideline, all guidelines also includes other key points. So I'd like to go on to explain our practical advice for companies performing research and development in Japan. So please be noted that the three-step discussion, disclosure, hearing is important to define standards or to decide the remuneration. So to simplify the thing, or to avoid double assignment or complex consent exchange in joint business, it may be recommendable to establish company rules to determine that employee inventions belong to the employer from the time the invention is made. At the same time, the company can reserve the right to actually file a patent application. That is, the company can decide that they do not file a patent application in their own name for each case. So other advices at this stage, so it can be to keep a good record of the discussions between the employer and the employees. And the second advice is to clarify who should be involved in the discussions for standards. So during the establishment of the standards, so discussions must be held between the employer and the employees. These 3 points are important at this stage. So let me skip this. So the third page shows how is the disclosure done. So disclosure can be done, for example, by internet or any other ways for all employees. This is an important point. And the last one is how is the hearing done? The employee inventor's opinion on the amount of the economic benefit must be heard. So in this step, inventor's opinion must be recorded. And the employer and the employee do not need to come to an agreement on the economic benefits but this sharing step is quite important for reasonable remuneration. So here is a special advice for companies who have joint business in Japan. So when your research and development partner company performs research and development in Japan, be sure that the partner company has established company rules, including these 3 steps. Otherwise, there is a potential for the previous mentioned double assignment and complication. So here is a very rough summary of my talk. Principles of Japanese patent law regarding employee invention. So there are 2 important points. So in Japanese patent law, one is encouraging invention, and second is equity between the employer and the employee. The employer needs invention by employees, and employee needs environment the employer offers. And third person, the Japanese government wants inventions to be used. So among these 3 parties, there must be a harmony. So, and in the Japanese patent law, this harmony is quite important. And content and action fitting the specific conditions in each field and the company are necessary. So the Ministry of METI issued the guideline. So finally, we return to the blue LED patent. So of course, no doubt that the blue LED invention is distinguished. So, and Nakamura invented so many, 300 patents or applications. So he is so productive. On the other hand, there must have been many collaborators, not only the immediate vicinities, but also indirect cooperators. Other engineers may have failed, but the result of their trial and error must have been valuable for the inventor. The inventor was promoted to a higher position. So according to these aspects, Nichiya seems to gather sympathy in Japan more than Nakamura. So this is a typical Japanese way of consideration of the employees' invention and deliberation. Thank you for your attention. So my talk is over.
So good morning, good afternoon. This is Robert Berner from Truck Munich, and I'll directly take over from Akira because I think we're already running behind schedule. And I'll try also to keep the timing in, although I've got a lot of slides. But as you know, this will be recorded and you may be able to download the slides. So well, please excuse if I'm going fast through some of the things. So we're going to give a brief overview about the legal systems concerning employee inventions. In Japan, we already heard from Akira-san, and from Germany, and then France, UK, and Italy. I will concentrate on Germany, not only because I'm German, but also because I think in Germany it's the most complicated system which is in place. We will then go over to the ownership of an invention in case an employee makes the invention. We will discuss the remuneration for the inventors and give 2 or 3 case examples, mainly from the UK in this case. And so let's head off. Part 1, an overview of the legal systems. In Germany, we have a specific law, the German Act on Employees' Invention, which provides a very detailed framework for first point, the ownership of inventions made by employees, and also remuneration issues. And if there are discussions between the employer and the employee about the remuneration, which most of the time happen, then there are specific guidelines provided by the legal text in order to give some schemes for determining the remuneration. The Act on Employees' Inventions in Germany was first introduced in 1957 and last modified in 2009. I will head out just some of the main paragraphs here. The first one is paragraph 1. This law applies to inventions and to technical improvements. And that is by employees in private employment, employees in public service, civil servants, and also members of the armed forces. So there is no difference made between private employees or employees in public service with respect to this act. Inventions are only those which may be the subject of a patent or of protection as a utility model. On the other hand, the technical improvement proposals are other technical innovations that may not be the subject of a patent or protection as a utility model. The main issue is that according to the Act on Employees' Invention, inventions may either be tied or free. Tied invention means these are service inventions, and that's the one which are interesting here. Service inventions are made during the term of the employment, and they either result from the employment task in the private enterprise or in the public authority, or are essentially based upon the experience or the activities of the enterprise. And these are the main inventions we're discussing now, the so-called service inventions. What is quite interesting, the German Act on Employees' Invention is very friendly for the employee. And paragraph 22 of the Act exactly says that the provisions may not be modified by contract to the detriment of the employee. So you cannot, when you hire someone, put in their employment contract, well, every invention you make during your employment are automatically owned by the company. However, agreements are allowable if they have been made after the reporting of the invention. And also what's quite interesting with protection of the employee is that any agreements which are allowed by the law are null and void if they are manifestly inequitable. Meaning that if the compensation, that's also one of the main issues here, is not fair for the employee, any contract signed by the employer and the employee will be regarded to be null and void. What's also interesting, what happens if the employee retires? Well, the rights and duties of this law will not be affected by the end of the employment relationship. Because usually you can imagine all troubles between employer and employee mainly start once the employer either is fired or has retired, because you will not come to a lawsuit against your employer if you're still employed. So the section 28 of the law, 26 of the law specifies that even if the person retires or the contract is no longer valid, any rights and duties from the Employees Act will still be valid. So when is the Employee Inventions Act in Germany applicable? Well, it depends on the contract and on the regular workplace of the employee. If the contract specifies that German law is to be applicable, then it is clear that the German Employee Inventions Act is applicable as well. In this case, this is also valid if the employee is permanently working outside Germany, meaning that if it's not for a determined period of time and there's no intention for him to resume work in Germany. As I said, if the contract refers to German law, then this doesn't matter. However, if the contract does not specify that German law is applicable, then if the person, the employee, is permanently working outside Germany, then the Employees Inventors Act in Germany is not applicable. What happens if people start to fight either whether the invention is a free invention or a service invention, or whether there's a problem with the remuneration? Okay, well, usually, as I said, that's mainly the case after the contract between the employer and employee has ended. And what is quite good in the German law, you can't go directly to court, because you have to go to an arbitration proceedings, and only after this arbitration between the employer and the employee has been finished, then you may start the judicial proceedings. And this arbitration board, which handles all the conflicts in the related to the German Employee Inventors Act, it's part of the German Patent and Trademark Office. And since it's a centralized office or centralized arbitration board, they of course have a lot of experience, and usually it's rather rare that some party then afterwards starts a court action after the arbitration has been carried out. So that's the legal system in Germany. What's the situation in other countries? Let's start with the UK. Employee inventions are regulated in sections 39 to 43 of the Patent Act. And usually there's a general assumption that employee inventions belong to the employer if the invention is made during the course of the employee's normal duties, and the employee had a special obligation to further the interests of the employer's undertaking. If the employee makes any other invention, then it shall be taken to belong to the employee. And of course, this general assumption is rather, it needs some interpretation. And there's always a question whether, according to the circumstances, the invention really was made under these conditions so that the invention would fall to the employer. So as a general advice, it is better in the UK that inventors are directly asked to enter into an assignment, assigning over the invention to the company, which is not an issue in UK law. Quite interestingly, the UK law does not have a requirement for routine payment of inventor remuneration. There is a compensation, but that's only in the case of outstanding benefit. So if the invention creates an outstanding benefit for the company, then there has to be a payment to the inventor. However, outstanding benefit is a very high hurdle, and it's measured having regard to the size and nature of the employer's undertaking at all. So we will review that later when we discuss a bit about the remuneration practices in the European countries. How's the situation in France? In France, the inventor who is working for an employer, if he makes an invention, these are categorized in 3 different categories according to Article 611 to 617 of the French Intellectual Property Code. The first category are the inventions de mission. So these are made by an employee who is paid to make inventions. That's usually about R&D people, or if you contract someone specifically to solve a problem and provide some inventive ideas. These inventions, they belong to the employer, but the employer is obliged to pay a reasonable amount of money. Well, there is no legislation about the total amount, but usually in larger organizations and companies, there is a compensation about 500 to 1,000 euros per invention at the date of filing of a patent application, and about 1,500 euros on the date of the grant of a first patent, which is based on the invention. If there is a legal dispute in these cases about the compensation, whether it's a reasonable amount, usually the judge is, he should not take into account the financial success of the invention, but only about, what's reasonable at the time when the invention was made, the invention was communicated to the employer. But to be honest, in the practice, it's quite the default position of the judges that they have a look at the financial success of the invention. The second category, well, that's inventions which are done by employees who are not supposed to do inventions. So if you have accountants, HR people, or even the cleaning lady, in this case, the invention is the proprietor of the inventor. However, if the invention is in the technical domain of the employer has the right to take possession of the invention by paying the juste prix. So again, he has to pay a fair and reasonable amount. And also, there are of course a lot of discussions what's a reasonable and fair amount. And also in case of court actions here, this amount should be evaluated at the time when the employer decided to take control of the invention. Again, as in the first case, in practice, the judge will take into account the financial success of the invention. The third category in France is inventions done by employees which have nothing to do with the activity of the employer. So imagine you're working for a car company and you make an invention related to food storage. These inventions, of course, belong to the employee. In Italy, the situation is quite similar. It's regulated in Article 64 of the Italian Intellectual Property Code. And you also have three different categories of employee inventions, and you've got one additional category for employees of public entities like universities or the like. In the first category, the employee is paid for inventing, meaning that, yeah, well, of course, you've got a special contract to solve a technical problem, and there's an invention which solves this problem. Then, of course, the invention belongs to the employer, and the remuneration is covered by the standard salary, which seems to make sense in this case. The second category are the so-called work-based inventions, and these are made by employees which have a role in the company which could lead to inventions. And that's R&D people, product developers. In these cases, the invention belongs to the company, and like in Italy, like in France, the inventors are entitled to a fair reward. The third category in Italy, well, it's all the other inventions, meaning that's a negative definition. If the invention doesn't fall into the first two categories, then it's got to be the third one. That means that these are employees which have, these are inventions made by employees which have a role which usually doesn't lead to an invention. Again, like HR people, accountants, cleaners, or caretakers. The invention belongs to the employee. However, the employer is entitled to an option or a license on the patent. And that option includes acquiring patents abroad. So if the inventor decides to file patent applications worldwide, the employer is entitled to an option on the patent applications or to license these. And this option needs to be done within 3 months from the date of the communication of the patent application. In the fourth category, we've got university researchers or researchers in other public entities. In these cases, the invention belongs to the employee. So that's a brief overview of the legal system on employee inventions in Germany and the UK, France, and Italy. Let's move on to the second part. Who owns the invention if it's an employee who makes the invention? And to be honest, this part mainly will deal with Germany because it's a quite regulated and complicated system, whereas the UK, France, and Italy, we already briefly discussed in the first part, so well, we'll concentrate on Germany here. Well, in principle, any invention made by an employee, it belongs to the employee unless the employer claims the invention for him. And there's a very strict procedure in this context with a very strict deadline regime. According to Section 5 of the German Act on Employee Invention, any invention needs to be immediately reported to the employer. The employer, on the other hand, has to immediately confirm receipt of that invention. After that, according to Section 6, the invention will be automatically deemed as claimed by the employer if it's not actively released within 4 months after the report of the invention to the employer. And that's very tricky for employers. This section of the Employees Inventors Act was amended in 2009. Now it really means if you're an employer and you receive a report of an invention and you do nothing, after 4 months you will be regarded to have claimed that invention. And there's a lot of consequences for both sides in this context. And I just can give every employer the strict advice: if you receive an invention report, docket your deadline of 4 months to decide whether or not you want to claim this invention. Let's start. What are the duties of the employee inventor according to the German Inventors Act of Employees? Well, according to Section 5, the employees are required to notify the employer without undue delay and in writing. According to Section 15, the employee must then assist the employer in acquiring the industrial property rights, and he shall be obliged to make the necessary statements. So if the employer files a patent application, the employee is requested to be of help during prosecution, if there are assignments to be signed, if there's technical discussions during office action replies. The employee needs to be helpful to the employer. Further, if the invention is a free invention, so it's not an invention which falls, which is not a service invention, meaning that, as I said, for example, if it's not based on the experience which the employee gains during work and it's not during his standard work, the invention, even then the employee needs to inform the inventor, and he must offer the employer at least a non-exclusive right to use the invention at reasonable terms. Further, an employee has the obligation to keep a service invention secret as long as it has not become free. On the other hand, from the employer's end, there is a lot which comes with the invention report. As I said, he first needs to confirm the receipt of the notification. And then after this 4-month period, he has to decide whether to claim or to release the invention. If he claims the invention or uses the invention, he has to pay a remuneration. And the most important point is he has an obligation to file without undue delay a patent application for Germany. So if you miss the 4-month deadline after your receipt of the invention report, well, you claimed the invention and you're obliged to file a patent application, at least in Germany. And of course, if you really don't want the invention, you're still obliged to file an application. And also, if you want to file applications in a foreign country, you can do so as an employer. But if you do not want to file an application in a foreign country, you must release the invention to the employee. Meaning that if you, for example, you file an invention in Germany, and afterwards, for Germany, that's fine, it's enough for me, Germany is my main market, you have to offer filings in all the other possible countries to the employee. And he can then, at his own cost, decide whether or not to file his invention, let's say, in the US or in Australia or Japan. Similarly, if the employer files a patent application and then decides to abandon it, loses his interest, he has to offer the patent application to the employee. And if the employee decides, I carry on with this patent application, the employer needs to assign the right to the employee. So from the employer side, there's a lot of duties coming with employee inventions. And the question is how to avoid all these duties and how to get rid of them. Imagine you receive an invention report which is interesting. You want to claim the invention, but you do not want, for example, to offer foreign filings to the employee, even if you don't want to do that. Or even if you want to abandon an application afterwards. You don't want to, well, tell the inventor and ask him for his opinion here. So what can you do as an employer? Well, as we learned before, you cannot, have it in your contract that the employee, forfeits all his rights stemming off a invention. However, that's again Article 22. Agreements which are made prior to a notification are invalid. However, once you receive a notification of an invention by an employee, you can have an agreement with them. And that's how it's done by most of the companies here in Germany. They sign an agreement with the inventor upon receipt of the invention disclosure and if they decide to claim the invention. So usually, well, let's call it an incentive system. As I said, it's a contract signed between the employer and the employee after the notification of the invention. And in most cases, there's a lump sum payment coming with this in order to, well, motivate the employees. And but if you pay something at that point, well, you have to take care because that may not be credited against a remuneration later if you start to use the application. And usually, as I said before, the employer wants to get rid of all his duties, and therefore, in such an agreement signed after the claiming of the patent of the invention, usually it's done with combination with a waiver of rights, meaning that the employee waives his rights. For example, to release of the invention in foreign countries, meaning that if the inventor signs that agreement and receives a lump sum from his employer, then the employer is not forced to release the invention for foreign countries according to Section 14. Or he's not even forced to file a national patent application. Or he's not forced to inform the inventor about the prosecution history and what's happening there. And also, he's not forced to offer the patent application if he wants to abandon it. So you have to imagine, if you're an employer, you send out an assignment to the inventor. Here, I offer you X euros, and in return, I'm free not to file an application even if I deem the invention to be important. I'm free to release the invention to other foreign countries. I don't need to inform you about all these things. And how much are the established prices for, well, obtaining such waiver of rights? If it's only paragraph 14, so if you not obliged to release the invention for foreign countries, well, an amount of 150 to 300 euros seems to be usual. If you're trying to get rid of offering the patent application, if you want to abandon it, it's about also 150 to 300 euros. If you want to combine these, well, it's about 250 to 500 euros as a lump sum. If you want to combine that with a waiver of your duty to file a national application, well, it's 350 to 600 euros. And if you want to have everything covered and also limit the right to information, well, you should have a lump sum payment in the amount of 1,000 to 1,500 euros. And as I said, you have also to think about that as an incentive to your employees to make inventions. Again, you have to take care that this amount, if you pay it with claiming the invention, may not be credited against remuneration at a later point. So as a summary, usual practice in Germany is the inventor has to file a report of invention, which has to be acknowledged, the confirmation of receipt by the employer. The employer has 4 months to decide whether or not to claim the invention. If he does not actively give free the invention, it will be automatically claimed. And usually, if the employer decides to claim the invention, he informs the inventor and offers to sign this agreement, where usually the inventor gets a lump sum payment, and on the other hand, the employer gets rid of all the duties and obligations which usually are a burden to him according to the Inventors Act in Germany. Well, as I said before, the ownership of the invention in the UK, France, and Italy has been briefly discussed before, so I'll just skip over here. So, part 3, remuneration of employees' inventions in Germany, UK, France, and Italy, and relevant case law. As we said before, in Germany, the employee is entitled to a reasonable remuneration unless the employer releases the service invention. Such a remuneration is due as soon as the employer uses the invention, regardless if there has been a patent application filed, granted, or not. And, well, usually there are also agreements signed between the inventor and the company at this stage, which then define what type of payment of remuneration is done and the amount. And well, with respect to the type, there are two different categories you could use here. First would be you pay specific lump sums, or you pay an installment according to the real use of the invention. And to be honest, you have to imagine if you're a company and you have an invention covering your products, and every year you have to establish how many products covering this invention did I sell, what was the turnover, what was the turnover in all other countries, and then I have to decide how much of that is due to be paid to the inventor. Usually, many companies try to avoid that and go to lump sum payment, as we still will see later. If such an agreement cannot be reached or doesn't exist between the employee and the employer, well, the remuneration is based on the legal framework of the remuneration guidelines here in Germany. Now it's getting complicated. The guidelines, they provide a complex formula to calculate the inventor remuneration. So V is the remuneration, and that equals to the invention value. And that is usually based either on a license analogy. So you take the number of products sold, and you take a common license, which is about 5%, 3%, depending on the business sector. Or you just take an invention value as an estimate of these values. And then you have to multiply that by a proportional factor, which is made up by three different parts. First is what was the role of the inventor in identifying the problem solved by invention. Then what was the contribution of the invention to the solution of the problem, and what are the duties and position of the inventor within the company. And then you have to multiply all these with X if you have more than one inventor. As I said, that's quite complicated, and I'll give you just a rough idea with an example. If you have an invented value, which is based on a license analogy, you have a net turnover of $2.5 million, and you have a fictitious royalty rate of 5%. And then if you have a proportional factor of 15%, which is now then based on A, you have the invention was developed upon an order, which means then your part A of that factor is 2, according to the guidelines. Then it's based on a typical work of the inventor, and it was heavily supported by the company. Then B would be 1. And if the inventor has an average position in the R&D department, meaning that it's not a team leader, but on the other hand, he's not, the cleaning lady, then C would be 5. And according to all these tables and formulas provided in the remuneration guidelines, you would come up with a proportional factor of 15. So Well, a fair remuneration would be $18,750 US in this case. As I said, in order to avoid all this complicated calculation based on your yearly turnover done with the products in all the markets and having to, well, calculate the remuneration on a yearly basis, many German companies nowadays use lump sum payment agreements as a preferred option, because you can imagine the administrative burden if you have to, well, find out all the figures yearly and then to calculate them. And usually you have agreements between the employer and the employee where you have several lump sum payments at several steps of the procedures. So one payment could be when a patent application is filed. Another lump sum may be due when the patent was granted. A third lump sum payment may be due if the employer starts to use the invention. And of course, such a payment, the money, how much the lump sum is, it could depend on the value of the invention for the company. And as we learned, the German Inventors Employees Act is very friendly to the employee, and we learned that the remuneration needs to be fair. Every agreement in such a lump sum payment agreement, it should include regulations that you have a review whether the lump sum is fair in view of the success of the invention. For example, you could say, well, okay, a third installment of the lump sum is when we start to use the invention, and 3 years later we will review if the amounts paid so far have to be considered as fair if you consider the success which the company had with the invention at this time. There's one more thing, of course, in order to establish whether such an amount is fair, the employee has the option to verify the compensation. Of course, usually every employee thinks, well, the company will only pay what's the minimum amount, and I want to see whether that's fair. And the German Inventions Act for employees goes so far, it allows employees to review and demand accounting details. So the employee may ask the company, please prove how many units were sold, what's the standard license fee here, and then we will see whether the lump sum you paid is fair or the remuneration which you calculated is correct. And if the company doesn't reply, the employee can even go to court and ask for the company to open their books and to provide him with that information. This is a very critical point because the German Employees Inventors Act does not prohibit an inventor to assign rights coming from the Employees Act to other people or companies. So you can imagine that if an inventor would assign his right to information to one of your competitors, which then starts to ask you about your turnover numbers with your products, that would be a very nasty situation. And therefore, such an assignment should be taken care of when you sign an agreement with your employee, to make sure that the employee is not allowed to assign any rights which are based on the Employees Act to other foreign third parties. That was a very fast start and explanation of the German remuneration system for employees' inventions. Let's have a brief look at the other main European countries here. What's in the UK? In the UK, as I said, you have an outstanding benefit which is needed. Otherwise, the invention gets nothing. It's a high hurdle, and it's measured with regards to the size and nature of the employer's undertaking at all. So the Section 41 of the Act only sets out the factors to take into account in deciding an amount, does not set any percentage rates. And in fact, there are two main decisions in the UK concerning remuneration of employees' inventions. So the first one is in Shanks versus Unilever in 2017. The benefit of the invention was, well, quite some money. It was £24.5 million. But if you consider that the overall turnover of Unilever, being a huge multinational undertaking, it was much more, and this amount was really dwarfed down. Therefore, the benefit of the invention was not outstanding for the overall company, and the inventor got nothing. On the other hand, the other decision, there's only one major case where an award was made, and that's Kelly against GE Healthcare in 2009. And in this case, the benefit was £15 million, and it was outstanding because it helped GE Healthcare to grow to become a large company at that stage. And in this case, the court decided that the inventor should get 3% of the £15 million to be split between them. In Italy, we saw earlier that there is no remuneration if the invention is a result of an employment where the inventor's step is a subject. Then it's compensated by the salary. If the employee, however, cannot be considered to be compensated by the salary, an equitable remuneration has to be taken place. And that's the employer, the case if the employer acquires a patent or uses the invention, and then the fair amount needs to take into account the importance of the invention, the salary, the task of the inventor, and the contribution of the employer to the invention. It's a case-by-case decision, and it's also quite complicated. If it's a completely independent invention and the employer wants to use it, well, you're free to negotiate your price. How about France? If it's invention, invention d'émission, is really the compensation based on the salary? Well, as I said before, judges don't care about that. The Supreme Court made a decision here that the compensation is to be based on the value of the invention. There are some, rough ballpark figures from case law in France. So if you have a non-exploited patent, the remuneration is between 1,000 to 15,000 euros. And if you've got an exploited patent, which is used by the company, then you'll have a remuneration between 10 and 300,000 euros, according to the importance of the patent. If it's not non-mission inventions, meaning that it's the inventions which are made by sorry, I have to review that. If you have your accountant make an invention, or people who are not supposed to do such inventions, then you have to pay a fair price. And at this point, you have to take the initial contribution of the employer and employee, and it's also a case-to-case decision. And if you have a look at the case law, there are cases and sums have been awarded between 7,500 and 150,000 for these. And if it's a free invention, well, then it's the free market price. So as you can see, in Europe, all the questions arising when an inventor is your employee can be quite complicated. And I think the most important and most strict problematic system is the one in Germany, because it has a very strict deadline regime. And also you have to take care whether your remuneration is fair if you compare it with the overall profit you make from the invention. This has been a very, very fast run through my slides. Please feel free, if you've got any follow-up questions, just drop me an email and I'll try to be helpful. It's quite a lot to pack into one webinar, and but as I said, I did my very best, and I hope at least that you can take something home. And if you've got any questions now, I think...
Thank you, Robert, for this marathon. You both have been great, super fast, and again, I'm sorry for the delay, to the speakers, to the audience. We are definitely late, so I would like to give just one time for one question to the audience. If there are other questions after the event, as mentioned during the presentation, you can send us the questions, and we can definitely forward them to the speakers. To review the webinar. The webinar will be published as usual after a couple of days on our YouTube channel, and the presentations will also be available on the website of the help desk. I would like to ask the audience if there is any question to write it in the chat window as usual.